Chef Ruben, I was just talking about emails that I had just received.
Yeah. Hi. Hello, everyone.
Hey, thanks for joining. Sean, you can kick us off now.
All right. We got a small crowd today, but hopefully, I know we'll record this conversation and post it on our website, as I'm sure, literally in real time. We'll get more inquiries and questions and emails about around what's happening now. And so, I want to welcome you all to this conversation. I know there's a lot happening right now, but it's important for all of us to stay informed about compliance and enforcement issues. Since I think Friday, I've been hearing from operators, even a reporter, about the I-9 audits and the responses that folks are starting to receive. And so our goal is to help folks today understand what happens after an audit, what the responsibilities are, what deadlines matter, and then just how to respond in a way that protects you, your business, and your workers. And so, as always, I want to thank our allied partner, Grossman, Young and Hammond, for the work that they've been doing over the past literally 365 days of. I know, I mean, our first conversation about this was in January of 25, I believe. And so, um, I know you all have been doing this work in our region in DC for quite some time, and so we just appreciate your continued partnership, and that's it. I will turn it over to Becky.
All right. Thank you so much, Sean. So, very nice to see you. I think that this conversation is very timely since, as we said, we're starting to see the results of the audits that were visited upon the DC restaurant industry last May. So, we had actually proposed and prepared this webinar before that started happening, but I think the time is right. So we are going to start with a presentation to sort of explain to you what happens after an audit is complete. What are the documents you might receive? What are the steps that happen? And sometimes we will take questions during a presentation, but today we're not going to do that because the Restaurant Association is going to record that part of this call. And then we will stop the recording and we will give you guys an opportunity to have a discussion and we can answer your questions. So let's get started with the conversation about what happens after an audit. So as we know, last May, there were about 200 I-9 audit notices that were served on DC area restaurant operators. And many of those employers are still waiting for communication from DHS or actually have now received communication from DHS. So we're going to walk through what employers can expect, what are the obligations regarding agency communication, and if it comes to that, what are your options to bring an audit to resolution in the civil context? So we might be getting ahead of ourselves a little bit, but in the event that there is a big fine, what are your options, basically? So, Mary, the first question is, what communication should employers expect from ICE after an I-9 audit?
Well, in the event that this is a purely civil investigation, the first notice one gets from ICE is a notice of suspect documents. It can be served either in person. The agents will come to the restaurant and serve you with a notice and ask you to sign to evidence that you have had personal service. Alternatively, they can serve you by certified mail. And I find this to be troubling in some respects because when the service comes in, the owner is not always informed that they've received this notice from DHS. But the delivery and the signing at the place of the business starts the running of a 10-day period for responding to this notice of suspect documents. The notice typically provides you with a list of employees whose documents have been reviewed by an HSI, that's Homeland Security Investigations auditor. And the auditor has determined that the document does not appear to relate to the employee, or that the information in the document doesn't correspond with information in the DHS automated systems. There's no record of it having been issued, in other words, to the individual. Or it is, a fake, meaning it may relate to somebody else, but it doesn't relate to the employee at issue. When you get this notice, you're instructed that you have 10 business days to notify the employee that their documents have been identified as suspect by ICE, and that they are obligated to prepare a new I-9 under your supervision and to present documents which relate to them, original documents which relate to them and are acceptable on the list of acceptable documents, but are different from the documents that ICE has already determined to be suspect. Now, we've had 2 or 3 clients who got these notices last week. They informed the subject employees of the situation, and not unexpectedly, given all that's been happening and reported on the news, these employees did not show up for work. In other words, they're gone because they don't have new documents to present to you that will pass ICE muster. But occasionally, you will get an employee who has other documents to present and who insists that these documents relate to them and they are valid. You are obligated to have them prepare a new I-9, and you're obligated to complete that section 2 of the I-9 by reviewing the documents, determining that they appear to be valid and relate to the employee, and recording them on the form. If you're represented by counsel, you can provide these to counsel, and counsel will deliver them electronically or in hard copy to the agent who has signed the notice of suspect documents within the 10 business days that are indicated in the notice. What ICE does with this information is to review any new documents that have been presented and report back either to counsel or to the employer that the documents appear to be valid and permit the employee to continue working. If that is not the case, then they inform the employer that these documents continue to be suspect. At that point, you will be told that continuing to employ these individuals beyond the date of this second notice would constitute or expose you to liability for continuing to employ an individual who they believe is not authorized to work in the United States. And the burden would shift to you as the employer to prove otherwise if you went to hearing on it. Generally speaking, if you're going to retain the employee, you should consult counsel to see if there is a valid basis for continuing for believing that the employee is in status and should be entitled to continue working. Right, that is the notice of suspect documents.
And Mary, I have a few questions for you. So the first relates to service of the notice of suspect documents. I know that for clients we represent that we have received the notice of suspect documents via email. Is it possible, do you know, for employers to receive it via email, or is it only by in-person delivery or certified mail?
If they're not represented by counsel, it is only by in-person delivery or certified mail.
And you prefer in-person delivery to certified mail?
No, I do not.
Okay.
I mean, No one wants agents back in their store,
Right.
eyeballing people and potentially confronting them and asking for papers. We've talked before about the fact that restaurants are public facilities, and when they're inside, they are free to go up to anybody and ask for identification and confirmation of status. So, I mean, in a perfect world, you've got an accountant who's going to receive or the owner's going to get the certified mail and will act on it promptly. But this is not a perfect world, and owners are busy, employees are busy, managers are busy, and things fall between the cracks. You probably should alert your staff, whoever typically receives the mail, to be on the lookout for a notice of for any communication from Homeland Security, and notify them that you should be provided with a copy of that promptly, particularly if it's sent certified.
Okay. So to be clear, if you're not represented by counsel, it would be better to receive it by certified mail than in-person delivery.
Yes.
Yeah. That's what that was.
Sorry.
Richard, if you want
Okay, I'll wait.
yeah, this is, if you don't mind your question being recorded, feel free to answer it now, but otherwise we'll have an unrecorded session at the end where you can freely ask any questions you would like.
Got it.
Okay, so notice of, and then my second question, Mary, which we might get to later, but it occurred to me, because we have seen some sort of long lists of employees. So you explained the process for collecting documents and then terminating employees who don't present documents. I have had cases in the past where I was able to negotiate a sort of gradual release of employees.
Yes.
I'm guessing that is not going to be possible in 2026, but I was curious to know your thought about that. If it's half of your workforce, do you think that there's any hope of having sort of a gradual release?
In prior administrations, Becky, I've always had success with a gradual release, and informing portions of the workforce, getting approval ahead of time for the rollout plan, when you will inform employees, when they will have to respond, and getting that information back to ICE. Given the current administration, I don't have any experience since the Trump administration took office of them granting additional time. In fact, the letter says no additional time will be granted.
Right. Okay. That's what I thought. I just wanted to make sure that we were on the same page. Let's talk about a notice of technical paperwork violations. And I know, Sean, one question you asked is, have we seen any audits that came back clean? I think that, that would be unlikely, in the current climate, but frankly, I would not expect to see a lot of notice of technical paperwork violations either. But Mary, tell us what that is and, what you think when that might happen. Well,
this is the reason we have a mandatory notice of technical or procedural violations is because Sonny Bono, you remember him from the old days? When he was in the House of Representatives, he had a restaurant and he was audited and fined a substantial amount of money for what he classified as technical violations. In 1996, when they amended the Immigration Reform and Control Act, they created a right for employers to be given notice of all technical violations and a 10-day period to correct them. And if they are properly corrected, to relieve the employer of any liability for a fine associated with those violations. A technical violation could be something like this. In Section 1, if the employee failed to record his address, that literally is, I think, the only thing. If there could be a few pieces of information in the biographical data section of Section 1 that would be considered procedural. In section 2, if you fail to complete all of the documents in the proper order, but you attach copies of the documents to the I-9, that's considered to be a technical violation. They may serve you with or give you an opportunity to fill in the missing information from section 2 in response to the notice of technical violations. Substantive violations, you don't have a right to correct. For example, in section 1, if the employee hasn't signed it or hasn't checked off what his immigration status is, or in section 2, if the employer has not signed the attestation, that is a substantive violation. Or if you fail to record the documents and you have not attached legible copies of the employee's documents, that is a substantive violation. You don't get an opportunity to correct those before a fine is assessed. So, to the extent that there are opportunities to do this, you do it and you turn it back in. If you don't avail yourself of that opportunity, the procedural violations can be converted to substantive violations and fined along with other violations that are found in the I-9.
All right. And Mary, that takes us to the notice of intent to fine. So can you talk about what's a notice of intent to fine? What does that look like? What will it symbolize? What will it mean?
Well, it is a notice that of the amount of fine that DHS proposes to levy upon the business for violations that are found in connection with the audit. There are 2 categories of violations. The first category has to do with paperwork. Paperwork violations, meaning some defect in the way the form has been completed by the employer. Typically, they will divide these violations into section 1 violations, section 2 violations, and section 1 and 2 violations combined. They will list out the names of employees whose I-9s are subject to these fines. Now, since we talked last April, or maybe it was earlier than that, fines have been increased. Why? Because they're subject to an annual inflation index. And in July of last year, the Department of Justice, which adjudicates these cases, applied a factor, an inflation factor as determined by the Consumer Price Index. So let me see if I recorded what the current ranges are. For a paperwork violation now, the range is $281 up to $2,861. These are base fines. The range where you fall within that range is dependent upon the percentage of violations that are detected in your total inventory. So if you give them 100 I-9s and only 10% of them contain substantive violations and uncorrected procedural violations, then your fine is going to be, let's say, in the first quartile of the fine range, probably in the range of $500 per I-9 that's defective. If more than 50% of your I-9s produced contain uncorrected procedural and substantive violations, the fine will be closer to the upper end of the range, meaning closer to $2,500 or $2,600 per I-9 that is defective. This is the base fine. The base fine is subject to aggravation. Aggravation means there are 5 factors. Without going into all of them, if you've ever been fined before for I-9 violations, they can add another 5% to each fine assessed. If if the I-9s that are identified, the employees whose I-9s are identified, are associated with individuals who are not authorized to work in the United States, that's another 5%. The notice of intent to fine will tell you the aggregate amount that has been assessed for all paperwork violations, both the base fine and any aggravation figure. Okay, I've covered the first category of violations that can be covered. The second category of violations that are reported in the notice of intent to fine relate to knowing violations, meaning that you permitted an employee to work who was unable to present you with documents evidencing his identity and work authorization eligibility, or you accepted a document which were counter to that. For example, if you permitted an employee to work who presented a Mexican passport to you, and you recorded that as the list A document, you are deemed responsible for knowing that that document does not authorize the employee to work in the United States. It evidences that he is a foreign national, and in order to work in the United States, he has to present you with a DHS employment authorization document and a restricted Social Security card. He did not. You did not record that. And so presumptively, that individual is not work authorized, and you can be fined for violations of that kind with a base of $716. And now the upper end is $5,754 as a base fine, again dependent upon the overall number of violations that are found in your inventory. The overall number. If you permitted an individual to work beyond the expiration date of his employment authorization document, that is also a knowing violation, because you are permitting an individual to work beyond the date when he was able to present you with evidence that DHS has authorized him to work. All of this is, of course, relates to the state of the files as they existed at the time that the audit was, the documents were collected last May or last June. A lot has happened in the interim. Employees who were on temporary protected status, many of them have been canceled, but those I-9s and that documentation was not inspected by the service as part of this audit. It could be in the future. They could come back, but it's not the audit that was conducted last May and last June and last July. So
Mary, I was going to say, I think we should talk about, so you get this notice of intent to fine. One option is you could pay the fines, right?
Yes.
Or what if you don't want to pay the fines or you can't pay the fines, what are your choices at that point?
Okay. Well, if you contest the allegations, and these are just allegations that are in the notice of intent to fine, and probably you've consulted with counsel and counsel has told you, I think we can contest this. What you have to do to prevent that notice from becoming a final agency order subject to enforcement in U.S. District Court is to request a hearing before an administrative law judge of the Department of Justice. And you do that by a letter. It has to be actually received by the district director at the address that's provided in the notice of intent to fine within 30 days of the date of service of the notice. And that's strictly applied. If you request a hearing, you can also request an opportunity to discuss settlement with HSI lawyers before a hearing, and to present them with evidence as to why you think the fine should be reduced. Again, counsel can help you structure arguments in this regard and can advise you on the likely success of being able to negotiate a settlement. I will tell you that while we've had a lot of success with settlements in the past, it appears that this administration is taking a very hard and that the attorneys who are at the bottom rung advising ICE in the jurisdiction where the notice was served have been denied the opportunity to engage in constructive settlement negotiations. They want everything to go to hearing, and that is unfortunate. Litigation is expensive. The ball is in ICE's court to initiate that litigation. You cannot. If you've requested a hearing, you've done everything you can do to suspend enforcement of the notice of intent to fine. It is then up to ICE to file a complaint with the Office of the Chief Administrative Hearing Officer to launch a case. And while the burden is upon the government to prove all of the allegations in the notice of intent to fine, you have an obligation to respond to the complaint, to discovery that they have a right to serve your own discovery, and to proceed with the litigation process in front of an administrative law judge. To be candid about this, it is expensive, and depending upon the size of the fine, it's generally beneficial to try to settle these things. We now have a new procedure with the administrative law judges. We have the right for the employer to request a settlement judge to suspend the litigation and to request an opportunity to meet with an experienced judge and to provide arguments to that judge as to why the fine should be reduced and by how much. This is dependent upon strategy. We have a lot of case law now that advises us of the situations where a compromise figure is appropriate. Let's face it, ICE goes for fines at the upper end of what they're authorized to charge. The courts have been cutting back and saying it should be in the middle range. Lawyers are familiar with those arguments. And where the law can be located is sometimes obscure, so it's difficult for a layperson to do that effectively themselves. But if you achieve a settlement with an administrative law judge, settlement judge, then that can be converted into a final order. And you can also negotiate for payment, how you can pay out, what the terms of payment will be, what the interest rate will be, how long you have to pay it back, based upon the reduced figure. I hope I haven't gotten that too confused, Becky. I'm sure there's going to be some questions that will come along. But
thanks, Mary. Yeah, I think we should probably, if you have, Mary, any final words of wisdom about this process, it would be great if you could share them, and then we can wrap up the recorded section of the presentation and do questions.
All right. What we've been talking about today is the civil resolution of these audits. What we have been seeing in some parts of the country is a criminal resolution, meaning that ICE has taken information gathered from the I-9 audit and determined that there is evidence that a crime has been committed, either by the employees or by the employer, and they decide to proceed on a different track, which means that they've got the U.S. Attorney's Office involved, and they could have been surveilling the business. They could have issued or obtained a search warrant to conduct a search of the business. If that happens, if you don't get a notice of suspect documents, if you don't get a notice of technical and procedural violations, you don't get a notice of intent to fine, but you are served with a warrant, you should notify counsel immediately because you need to be represented under those circumstances. It'll take longer for this to play out. You may also ultimately have a civil fine, but they're not going to play their cards yet with that. They're going to pursue the criminal investigation first. So I think we are going to have a follow-up presentation with a white-collar lawyer, very experienced in immigration defense, in a month or two. We're going to let this play out a little bit, but for right now, we were focusing on the civil resolutions in today's presentation.
All right. Thank you very much. We hope that that information was helpful to you.